All right, let's get going. I know it's been a long day for some of you. And just get the presentation up and going. All righty. And as I said, it's not terribly long, because this is one of those subject areas where you kind of have to get into it. It is very much a specialist area. So to give you a bit of background, when you in a big organization, you'll find that the labor relations or the employee relations, it's generally called employee relations, or sometimes also called stakeholder engagement or stakeholder relations. Although stakeholder relations tend to sit within corporate communications rather than, and stakeholder engagement is more under things like investor relations, community engagement, and those type of stuff. And that would sit under stakeholder engagement. And in big organizations, that area is called sort of, we called corporate communications, sort of in that area. And then what you find, and that generally sits with marketing. So sometimes that sits with marketing, or sometimes it even sits in a pillar of its own, or in a department of its own. Especially in big companies, you find that corporate communication sits within a sort of its own area of responsibility. But in smaller companies where you don't have that level of diversification, you find that employee relations and employee and sort of stakeholder engagement sort of sits within HR, and a little bit in PR sits within marketing, and investor relations that sort of sits within marketing. And when you find some stakeholder engagements, things like engagement with unions, engagement with other stakeholders like community, they would sit within HR. So sometimes those areas would overlap. But industrial relations, or IR, or labor relations, LR, is very much function within HR, especially when it comes to dealing with employees, understanding compliance. So let's talk about mandatory compliance, and with that word called mandatory compliance. And here I use the rules of the road as sort of as a bit of a way of breaking down or understanding what this means. So mandatory compliance are all of the rules, all of the set pieces of legislation that sets down the rules of engagement, that sets down the way we relate to our employees, the way the workplace, how do we make the workplace safe, how do we make the workplace fair. It sets out very specific rules of engagement in terms of how do we deal with discipline, how do we deal with collective action. And I'm going to throw out some of these words because they all have specific meaning, and they have sort of a very much a background and so forth. So that's a little bit about that. So I'm going to give you a bit of depth and a bit of sort of understanding as to why these things are there, because they sort of embedded in our shared history. They're embedded in our history and the way and where we come from. And I know the textbooks are very careful in terms of how they sort of relate this type of thing, how they relate labor relations. So labor relations, if you think back, during the years of apartheid, especially during the 1960s and the 1970s, the labor movement. Okay, so, and again, it's about setting context. So let's understand the context of some would say that the apartheid system was more of an economic system than it was a sort of a political system, or a framework around, a belief system. And at its heart, the apartheid system was about economics. It was about How do we extract value through mining, through agriculture, and how do we do it in such a way that it is at its lowest unit cost, through making sure that we have this pool of very unskilled, low-skilled, very cost-effective pool of labor that we keep separate. So we bring the labor in, and when we don't need them, we send them back and we keep them within certain boundaries. So that's the economic aspect of apartheid. And within that context, the labor movement was as much a political movement as it was the traditional Karl Marx socialist labor movement, if that makes sense. Karl Marx wrote Das Kapital way back in 1800s, towards the 1880 or something, around about there, and it talks about this traditional struggle between capital and labor, and he was the first one that introduced this two opposing powers within the context of capitalism, within the context of, you also need to understand, within the context of the Industrial Revolution that started around by that time, and the industrialization of labor, meaning suddenly you no longer had a little cottage industry where it was 2 or 3 or 4 artisans working and being apprenticed. Now you had the division of labor in which labor was split up. One artisan's job is now done by 15 highly unskilled, lowly paid people through repetition, through breaking up, literally division of labor, through breaking up a complex task into smaller elements that can be taught to somebody within 2 or 3 days. And with the help of mechanization, those smaller bits or smaller things or the smaller bits of labor can be done a lot quicker and a lot more efficiently. And that is really what the Industrial Revolution did. It broke up something that took an artisan maybe 15 years or 10 years to learn, to be able to do, and then be able to charge for that experience and for that labor. They broke it up into smaller pieces that through mechanization can be done a lot more efficiently and a lot quicker. So that's the context in which he wrote Das Kapital, and that's the context of the struggle between capital and labor, and that continuous struggle over time, and that tension. Fast forward to 1960s, 1970s, 1980s, South Africa, where you have this parallel, where you have this political struggle for emancipation, for freedom, within the context of African Pan-Africanism, in which there was this whole process of decolonization, in which the old colonies and you had independence. So that's Pan-Africanism, especially in the 60s and 70s, where a lot of African countries became independent. But the old colonial powers still tried to meddle and still tried to control the old sort of colonial states. Then you had South Africa, Southern Africa, you had Zimbabwe with Rhodesia, and that armed struggle that happened there for the emancipation of freedom, or and again, depends on which side you look at. It's, it was a conflict that was very violent. And then you had South Africa, Southern Africa, including Namibia, where you had the apartheid state with all of these laws. And within that context, you had this labor movement that started organizing labor around specific sort of values and principles. So it very much was a political movement as well as a labor movement within the South African context. And that is what made it unique within the South African context, as opposed to the labor movement in Germany, as opposed to the labor movement in the United Kingdom, in Britain, which was also very strong. Literally, the Labour Party was started in the late 1950s and early 1960s as a result of Labour calling out and saying, listen, we want a voice, we want to be part of the table. In Germany, the labor movement was also expressed through the Socialist Party and a Socialist Democratic Party and a Christian Democrats, not so much the Christian Democrats, but the Socialist Party, and all over Europe post the 2000s, post the Second World War in the 1960s, were all of these sort of labor movements expressed through the Communist Party, through the Socialist parties. You had Fidel Castro in Cuba, that very much was a sort of a socialist movement. So now suddenly labor, under the banner of socialism, not communism. Communism is a political system. Socialism is an economic system. Under the banner of socialism, and then you have capital under the banner of sort of democracy and liberal parties and the liberalization of trade and free flow of capital, and they were literally on this crash course towards conflict. And a lot of the labor or the labor movement's expression through their political expression was through socialist parties, and within Europe, especially within Europe, they came to power. They came to the table. They started having a voice, a political voice. In Germany, trade unions are exceptionally strong. In France, trade unions are exceptionally strong. In Italy, in Spain, trade unions are exceptionally strong, and they political voices through these parties. Literally, in all of those countries, you'll have a socialist party, but not as expressed in the old Russian Federation through communism, or in China through their pseudo-communism or pseudo-socialism that their political system is based on. So that's the context, long-winded context, but that's the context. So 1980s come about, strikes, labor movement, very strong. The labor movement was really the foil, was really the spearhead of the political sort of fight for political equality in South Africa. So labor was used as the spearhead to fight for political equality through stayaways, through strike action, because it was seen to be school children can run into the streets, but they will be shot and locked up. But when labor stay away for weeks and weeks on end, you cripple the country's economy. So the labor movement was seen as the spearhead, as the foil that can bring people to the table to start talking in terms of finding an alternative to what was before. So that's the context. Come the 1994 elections, we then have, yes, Zukanya.
So I wanted to ask, this form of striking, is it the only way that, let's say, the people in the labor section can express themselves or can have, looking forward, can have weight or have a say? Is it the only way? That's the question.
That is what Karl Marx said. He said it's only through collective action that labor can express itself. It's only their power lies in collective action, and as one is powerless, but many in many lies the power, and because one factory owner can shut down a factory and he can impact sort of thousands and thousands. One person can go to management and say this and this, and they can, stand up for something, and they can be fired. But if everybody goes through a collective voice, it's very different to fire them. So it is only through collective action that labor, when we talk about labor, labor has a voice. Yes. Good question.
So when it's intertwined with the political side of things, how South Africa handled the issue. I feel like the use of political, have proper English word, but I feel like the political influence has so much more weight in the collective for me because I feel like the politics plays such a dirty trick on the collective that we somehow believe that the men and women in politics have more power than the men and women on the ground, your everyday labor. That's my concern.
Yeah, no, that's certainly a good that's certainly an opinion, and it's one way of looking at it. And let me move on from 1994 to where we are right now. So now we've got 30 years. So post 1994, we needed to find another dispensation. We needed to find another set of rules. With the union movement being so strong, the new government needed to find a way of setting clear rules and clear guidance and clear guidelines. One to curtail the union movement strength. So that's the cynical view to reduce their sort of power. But the other view was that it was not just to reduce their power, but it was also in order to make it a more egalitarian system, to make it a system where both labor and capital carries the same sort of power in the relationship. Because if you follow Karl Marx's argument, is that this the very nature of this relationship is almost always driven to conflict because it is a contestable relationship. One owns the capital and makes all the decision, and the other one is powerless, or at least that's how Karl Marx sees it, powerless, and the only thing they have is the power to withdraw their labor. And this relationship is always contested. It's always based on conflict. It is always this highly sort of relationship that's driven through this inequality, through its very nature of its inequality. So the new set of rules was put together. Specifically, it started off with the Labour Relations Act of 1994, which sort of sets out the playing field. It says, this is how we are going to resolve conflict from now on, both collectively, and then the Basic Conditions of Employment Act was then put together to say that this is how we are going to relate to each other one-on-one. And then another key piece of legislation was put together, which puts the onus and responsibility on capital, on owners of capital, on management, to ensure the safety of all workers in all context, which is COIDA, which is sort of the Safety Act, and then the more contested part is employment equity, and employment equity through another piece of legislation, which is the BEE legislation, broad-based black empowerment legislation, was meant to rectify some of the past injustices and the past distribution through redistribution. Now, that is a highly contested view. It's especially now after 30 years, one looks back at it and one asks, has it worked as it's supposed to work? But what I'm asking you to do is simply look from a HR professional point of view, look at these pieces of legislation dispassionately, look at it just objectively and say, okay, this is the rules that are there currently. These are the rules that that I have to comply with. So as a HR professional, your role, your fundamental role is to risk manage. So what does that mean? Risk management. It means you have to manage, either Andrew, I see your hand, you have to manage the risk that employees in an organization pose to the company. So this is an important distinction, because, and that's the tension of all HR professionals, is that you are there to ensure and be the voice of employees and to defend them and to help them and to support them. But ultimately, your responsibility lies to managing risk to the company. Does that make sense? Because there's an important distinction that you need to understand. One, be the voice of employees to help them, to defend them, to support them, but ultimately you're there to manage risk to the company. If an employee, for whatever reason, poses any risk to the company, it is your responsibility to use the full might of all of the legislation in order to move that person out of the business. And that is your responsibility. So your responsibility isn't to management, but to the company that you work for. So that's the most important distinction. Yes, Andrew, you've got a question?
Yeah, two things, sir. The first one was BE, the way I see it, is pivotal part to any business, because I remember when I was doing tender documents and they ask you what your triple BE score is, right? And depending on the level you have of BEE is dependent on, firstly, whether you get more tenders, secondly, whether your business is run ethically or not. And I think currently in South Africa, it's a highly contestable topic, but it's also a highly pertinent topic, because if we can't run businesses, then we can't boost or increase the economy of our country, basically, right? And I don't know whether you agree with that to some extent or whatever. But yeah, that's just how I feel. I think BE is necessary, and I think all the labor laws are highly necessary. Talking about compliance and risk and whatever, I feel that if an employee, like you said, provides any form of compliance risk towards the company, they should be, dealt with immediate action, if that makes sense. So, but I also wanted to ask if there's certain circumstances where, although it can be a compliance risk to the company, where we don't have to enforce all the laws and provide a quote unquote second chance to said employee. Are there any instances where that is the case, or is it more often than not firing?
Andrew, that's a very good point. And I'll swing back to the Employment Equity Act on that slide when I get to it. So let me put it to you this way, especially our Basic Conditions of Employment Act and our Labour Relations Act. So what the Labour Relations Act did is it set up the structure within which all issues are dealt with, whether it is wage negotiations, whether it is strike action, whether it is any dealing with disputes. So it set up the structure through NEDLAC, which is an employer, which is a labor, employer, and government structure. It's like a round table where each part of them, and they made it round specifically, or just in principle a round table. Nobody holds the power, and it's a place where disputes between all three is dealt with, but also it's a place where they put together sort of white papers, and they do the research, and they put out documents, and they give guidance. So that's NETLAC. And then they, part of the Labour Relations Act, they also set up the CCMA, which is the Commission for Mediation Arbitration, and they also set up the Labour Court. So the Labour Court is above the CCMA, and these structures are meant to sort of deal with disputes between Labour and between Labour government and between capital or management, owners of capital. And that the Labour Relations Act is sort of the crown piece of everything. And it's really a brilliant piece of legislation in terms of how it tried as much as possible to limit the excess of labor and to bring capital in and force them to the table. So that the principle of the Labour Relations Act is that we negotiate before anything else. All disputes are resolved at a table. And only when that dispute, when negotiations break down to the point where we can't even look at each other, then we resort to the two ultimate sort of flex that we have. The flex that Labour has is strike action, withholding of labor, and the flex that capital have is lockouts. So they literally can't lock it is literally they lock the gate and nobody can come to work. And the principle is this: if you're not at work, you don't get paid. But that only happens in very extreme cases, because there's so many things that hasn't put in place to resolve that dispute. First of all, you negotiate. And if you can't negotiate, if you can't find a way around things, then you look for arbitration, no, for mediation. And if you can't find mediation, you then get appointed an arbiter who then looks at arbitration. And you can't do that, and then you have to take it to the labor court, and then a judge has to hear the hearing. So they put all of these things in place. That only after all of that, if there's a complete breakdown after that so the entire process is meant to force you at every point to talk to each other, until it finally breaks down. And then the ultimate flex from Labour is, I withhold my labor through strike action, or from employer point of view, they can do lockouts, and they can say, I refuse to let you into the premises because that is my right as an employer to lock you out, and therefore I'm not going to pay you until we resolve this issue. Okay. But that only happens after all of these things, after all of these avenues has been exhausted. And when a union applies for a permit to strike, they have to prove to the Labour Court that they've done everything. They've tried mediation, they've tried arbitration, they've tried negotiations, they've done every possible step, they've done everything. They must prove it before they get permission to strike. And the same as from employer, they must prove beyond any doubt that they've done everything in order to resolve the dispute before they engage in a lockout.
So, but does this also, sorry, I mean to hop on the same topic, but does it also apply to disputes within management teams? So can I give an example?
So that's a different one altogether.
Okay, because an example I have is basically I won't name the company and I won't name the individuals for their respect, but basically what happened was one person from management who worked in the commercial division decided to overthrow, per se, the CEO of the business, and rallied everyone behind him to try and let that happen so that he could take over as CEO and kick the other guy out. However, knowing what I knew at the time working for HR, is nothing was taken to CCMA and nothing was taken to court. And the only thing that was done legally was contract termination of the member of management, which to me made no sense. So that's why I'm asking, does it necessarily pertain to management disputes or not at all?
So this that I just talked about now, the dispute resolution process is done as a collective. So when we talk about management, it would be, and labor would be represented by a trade union, and then management would be represented by the managers or the owners of the company. What you're talking about is an internal, it's internal power struggle. So that would be guided by your code of conduct that you have within the organization. And that would fall under your basic conditions of employment. So I'll touch on code of ethics and code of conduct when we get to basic conditions of employment, because part of the code of conduct is your disciplinary code that sort of comes out of your basic conditions of employment act. And I don't know, Andrew, what that just sounds like an internal power struggle, and it just feels like something like that would have been guided by the code of conduct. So if those managers signed the code of conduct, there would be something along the lines of, if you bring the company to disrepute, or if you fail to execute orders, you will be your contract will be terminated under these conditions and so forth. But
Okay.
remember, those people they can appeal that. So they can say, you know what, you don't have any right to fire me. I'm taking you to the CCMA, which is the external body, to hear my case, because I think the dismissal was either was unfairly done. And there's two types of unfairness, which is one procedurally unfair or substantively unfair. Substantive means that the case you're bringing against me is unfair because there's insufficient evidence, or procedurally unfair, which means that the way you've done it is you haven't followed the process. So, but we'll touch on that now. But that's a very good question. Thank you, thank you very much. Yeah.
Thank you.
Great. So the Labour Relations, as I said, Labour Relations Act is a great piece of legislation. It was written over 3 years, and it was contested, it was negotiated, and the finer points of it was really, really sort of teased out. And again, it's one of those key pieces of legislation that was done in those first 3 years of our new democracy, which is one of our guiding pieces of legislation. You must realize this was done at the same time that we were writing the Constitution. And there's a few pieces of legislation that was written all at the same time: the Constitution, the Labour Relations Act, there was one other one, the BE, although BE is sort of the Broad-Based Empowerment Act. It wasn't really called the Broad-Based Black Empowerment Act. It was called something else. It was something about redistribution or rebuilding, property, private property, and property ownership act as well was also written, and these pieces, and also the Education Act. Oh my word, the Education Act as well was also written around about that same time, because these were areas that was fought over. They were contested because within the Education Act there was a lot of, it was the fight for survival around things like language and the right to use a mother tongue language for instruction. And that was areas where people were just not willing to budge. Within the Labour Relations Act, it was the unions was so strong, because remember, the union, the ANC won on the back of these strong unions. Ramaphosa was the chairman of the Mine Workers Union during the 1980s. He was a key person that was at the negotiations. He was a key leader within the ANC. The Mine Workers Union, COSATU, was a massive union that supported the ANC, and the ANC really won that first few elections through the support of the labor movement. And and the labor movement was brought into the ANC. Some would say co-opted into the ANC through being given sort of key portfolios and key minister and ministries, almost like as a thank you, as a you co-govern. So the Labor Relations Act was very interesting. I was at university at the time when it was being put together, and I was busy studying this. I was actually very fortunate to be in a class of a professor that was on the committee, on the writing committee, and he would share with us that they're busy with this element of it and they were busy with that element of it. One of my majors at varsity was in industrial sociology, what we call industrial sociology, which is essentially sort of sociology within the context of organizations. And then my other major was industrial psychology or organizational psychology. And he would share with us how the labor laws are being written and all of these things. And it was so interesting. So it set the scene. That's the pinnacle piece of legislation, which is the Labor Relations Act. And then the Basic Conditions of Employment Act is sort of non-negotiable terms to protect you. Now, this act is at this time. Heidi Bontley, you've got a question.
Yes, sorry to take us back. I wanted to ask, the high school that I graduated from, the teachers weren't allowed to be in a trade union. So I wanted to ask, how come that's allowed?
Oh, as the private school?
Yes, sir.
That's not allowed. That's illegal. Labor Relations Act, actually our constitution allows people to freedom of association. That's in our constitution, freedom of association. They can belong to any political party or to any organization, trade union organization of their choice. Yeah. They could have appealed that. They could have come together and formed literally a trade union or employee association or teachers union, and they could have gone as a collective body and said to management, listen, we want the right to organize because that's our constitutional right to organize. However, if they sign their contract saying at the beginning, and this is illegal, so that's an illegal contract. If they signed the contract and they said, I signed this contract and I hereby don't belong to a union, I won't belong to a union because while I'm working here, that becomes an illegal contract because if you're signing something that's illegal, it becomes the contract is null and void, becomes illegal, yeah. Only no, it's a bit unfortunate that they were put in that position, but our freedom to associate is enshrined in our constitution.
Yes, because I asked her, she said that that's what she signed up when she signed the contract, that she wasn't in a trade union while working. Then I was asking, how can they do that though?
They can't do that. It's illegal. It's illegal. But the thing is, if nobody at the school, if none of the teachers at the school as a collective body, or even individually, if none of them are appealing it or standing up to it, then that's sort of the treatment that they're getting, which is unfortunate. Yeah.
Okay, thank you, sir.
All right, no problem, Zukani.
So I want to ask, who holds the rule makers accountable of the rules that they set and wrote in stone? Like, who holds them accountable?
Who accountable?
The rule makers, like you were making an example that one of the lectures in your old institution was part of writing these legislation, right? Or part of the negotiations of what goes into the rules. But what I'm picking up is the people that set rules and limitations and ways of doing things in business and labor are some of the people that break the rules or know how to find corners and places to slip up, and who holds these people accountable? Because I mean, if I do it as a citizen or as a person who's working, I get arrested, right? Or I get fined, or I like my life is never going to be the same. But the people that wrote these laws and stuff, like, what is their repercussions or their consequences when they break the rules that they set down around the table?
Yeah, no, you're right. From a Labour point of view, Labour is set up democratically, so the trade union members elect their leaders through a democratic process, and there are different ways of, not different ways, but there's different sort of checks and balances to ensure that is done democratically. And again, that is actually set out in the Labour Relations Act. There's a section entirely of how to constitute a trade union, and what makes a trade union, and what are the systems and things that needs to be in place in order to qualify as a trade union and to register as a trade union. So all of those things are listed in there and actually defined, well defined. So my professor at the time, he wasn't negotiating, but he was just one of the writers. So the negotiations would take place, and then they'll get the information to say, how do you codify that into? He was a labor lawyer, and how to codify those negotiations into a law, as part of the act. So it was very interesting at the time. Great. So we've got the Labour Relations Act, we've got the Basic Conditions of Employment Act, which is one of those where we've now had time to sit with it. and it has been revised. It's actually been revised twice already. We've now had time to sit with it for a long time now, more than almost 30 years. Actually about 25 years. And over the 25 years, that has been sort of revised. So there's two arguments for it. The one argument is that because of the Basic Conditions of Employment Act, we don't have economic growth because international companies don't want to set up operations in South Africa because of our Labour Relations Acts. They are just too onerous. They difficult to abide by. They set all these unrealistic expectations on employers, and therefore international companies are not coming to set up operations here. It's difficult to fire people. The Basic Conditions of Employment Act or the Labour Relations Acts that we have protect the workers' rights, and they don't protect the rights of employers. And a person can do anything and they will get away with it, and it's difficult to fire people, and so forth and so forth and so forth. So you hear all these arguments against the Basic Conditions of Employment Acts that we have, and the Occupational Health and Safety Act and the Equity Act. You hear all these arguments against those as they are the so when there's arguments against labor, it is because of these acts. They're saying because of these acts, that's why it's so difficult for us to run organizations and for us to run companies, because you have all the rights and we as employers don't have the rights, etc. So that's a one view of it. And there's some merit in it. There's definitely some merit in it. So that's the one side of the argument. And the other side, the opposing side of the argument says that, listen, this is the only way in which we can protect workers, those people that already have jobs. And the Occupational Health and Safety Act is just about making sure people are safe and they don't die, they don't get hurt, and they're protected if they do get hurt. The Basic Conditions of Employment Act is there to protect workers, that you don't wake up one morning as a manager and you have an argument with your wife, and then an employee looks at you wrong, and then you just fire them on the spot. The Basic Conditions Act is meant to protect workers against those instances, against being victimized, against being used as scapegoats. And that's why the Basic Conditions of Employment Act and Occupational Health and Safety Act and the Employment Equity Act is there to ensure that the basic rights of workers are protected. So you have these arguments, these two arguments, and both of them have merits. Both of them are sound arguments. Both of them have evidence to support it. And those are two sort of held in tension like this because on the one side, the one side of things that yes, our labor laws are very onerous. They are very difficult to abide by. And if you are a company that grows above 50, because 50 is the cutoff, if you grow above 50, you suddenly have to pay all these levies, put all these things in place to protect workers and so forth and so forth and so forth. And then it just becomes too difficult for a small business. Will have to employ somebody to help them just be compliant and stay compliant. So that's the one argument which definitely have merit. The other side, Labour is saying, listen, if these laws weren't in place, you would still be treating us like it was apartheid. You would still be treating us like dirt. You would still be stepping on us. And this is the only way in which we can protect people. Then there's a third argument. And the third argument says, these laws are only protecting people that have work at the moment. What about protecting people that don't have work at the moment? And these labor laws are preventing economic growth, therefore preventing people that don't have work to have work. So you have these sort of tension, which is fascinating, which is because I don't know how it's going to be resolved. Because capital is saying reduce the labor laws, reduce the restrictions, make it more free. Capital will come from overseas and set up companies. I don't know whether that is true. I don't know whether companies will suddenly flock to South Africa if we don't have some of these rules to protect workers. And on the other side is, as labor, you're only looking after people that have work. You know, it's not just about the people that have work. What about the people that don't have work? And their answer is, but that's not our mandate. Our mandate is, as a trade union, we represent workers. We don't represent the unemployed. And then the argument is, but if we reduce some of these restrictions, maybe there will be more employment, and then your membership will increase. So it is a very, very interesting sort of crossroads where we're finding ourselves. And the unfortunate thing is something will have to break. Something will have to be done, because if overseas investors are saying labor laws and these onerous labor laws and these restrictions are what's preventing us from investing, then we need to ask ourselves, is there ways of still protecting worker rights and still protecting the sanctity of the worker in terms of basic protections enshrined within our constitution, while allowing flexibility for when companies come and want to invest in South Africa. So it's interesting. Yes, Bontley, you've got a question.
Yes, sir. I wanted to ask about overtime. How come sometimes overtime is paid and then you have overtime that's not paid?
It depends on what your contract is. For everybody. If you've got a contract that says this is your regular working hours, and if you go over those hours, then you qualify for overtime. The only time when it doesn't get paid is if you get time off. So your employer might say, you know what, you worked the extra 2 hours today. I'm not going to pay you, but you can come in 2 hours later tomorrow. So sometimes you do get time off in lieu of overtime.
Oh, okay, thank you, sir.
Okay. And that's often the case when it's a smaller organization. We don't have a big budget, and you'll say, you know what, I need this done for a client, so please do the extra few hours, but then just come in late tomorrow, or you can leave early tomorrow in lieu of the hours that you work today. Yeah. So the basic conditions of employment act covers everything from overtime, rest periods, minimums, annual sick leave, family responsibility leave. It ensures you're paid correctly and on time. It's a safety net. for employees, etc. It really does cover a lot of things. But as part of the Basic Conditions of Employment Act, further to Andrew's point that I made earlier, is that every company must have 2 pieces of documentation that you as a HR professional will have to draw up. The one is a code of ethics. This is how we work here. This is what is ethically acceptable. These are our values. It's driven by our values. And then a code of conduct. So code of conduct stipulates exactly all of the sanctions of it. So code of conduct, if you do this, if you misuse company property, this is the sanction, meaning you'll be counseled or you'll be you liable for a disciplinary hearing in which you will be issued with a written warning, a first written warning that will stay on your file for 6 months. So the code of conduct stipulates all of those offences and the sanctions that goes with it. With the code of conduct is normally what we call a disciplinary policy. So every company will have a disciplinary policy in place, and that disciplinary policy will have detailed breakdown of all of the offences, the sanctions, the process of appeal, conditions for when a person gets summarily dismissed, etc., etc. Again, your code of conduct needs to be, or not the code of conduct and your disciplinary policy needs to be done within the framework of the Basic Conditions of Employment Act. So you can't draw up a code of conduct that says that you're not allowed to take sick once, you're not allowed to take sick during the week. You're only allowed to be sick over the weekend. You can't have that as a code of conduct, because that falls outside of the Basic Conditions of Employment. OHSA, or the Occupational Health and Safety Act, is about safety conditions and keeping people safe and healthy. And part of this links into what we did last week, which was employee well-being. You know that we touched on employee well-being last week, and part of that was occupational health and safety as well. And then there's the Employment Equity Act, which is really about, it's not just, Employment Equity Act is not just about race, it's about gender, it's about religion, it's about disability. So it's a combination of all of those. And it's meant to allow marginalized groupings preferential entry into the job market, into organizations. And the way that they do that is through an incentive. An incentive really comes through the BCEA Act. So the incentive is that if you employ people with disabilities, so you're not allowed to discriminate on the basis of race, gender, religion, or disability. If you employ people of a certain gender, more at certain levels of disabilities, then you have, and of race, then there's an incentive for you through the BCEA sort of act as well as scorecard. So that is the Employment Equity Act. Yes, Bontley.
Yes, sir. I wanted to ask you personally if you think there would be an environment where we wouldn't need any of these acts. Because I noticed like some countries have dropped their acts that protect their employees because they feel like it's unnecessary.
Which acts, Bontley?
The employee, the one that we currently answer.
Oh, the employee. Oh, the equity. The
Employee equity.
Yeah.
Yes.
Employment Equity Act. Yeah.
Yes.
So the Employment Equity Act is about protection and unfair discrimination. It's not so much about BCEA. So the Employment Equity Act is about saying that you're not allowed to discriminate against someone because of their race, or because of their gender, or because of their disability, or because of the religion. So you have to treat everybody equally, and you're not allowed to discriminate. So the Employment Equity Act is about protection and to stop unfair discrimination. Yeah.
So I was going to say, when I was again working in HR, and before I had got into HR, I did my interview to get into the job I had. Um, and one of the questions that surprised me was, and I think it's slowly being added now into interview panels too, is are you comfortable as an individual working with a member of LGBTQ IA plus community, kind of thing. And then when we did our screenings or any of our interviews or whatever, we would ask the same question to the particular individuals that we were wanting to hire. I don't know on your end whether you've started seeing that trend too now, in more so in the last 5 to 10 years. But yeah, I just thought it was interesting to kind of mention the fact that nowadays on your panels now for interview panels, they will ask you questions like that. And even if they do know your religion, i.e. mine being because I'm Christian, they are more inclined to ask you those questions because they know Christians are against those kinds of things. So yeah.
That's a very interesting question, Andrew. First of all, that is a very gray area.
Yeah.
Because in an interview situation, you can be seen as being discriminated against. Because
Yeah.
what if I say no, I'm not comfortable working alongside somebody from that community, then I'll be unfairly discriminated against for that job if I say no. So it's a gray area to ask a question like that. So what they will do is a lot of the interviewers, they will do it very in a coded way that it is not so direct. So they'll ask, how do you feel about this community? Would you, in a work, have you worked in the past with a colleague that identified as being part of this community? So that's one way of asking it in a very coded way to find out and to gauge your level of discomfort or comfort with it. But again, it's about risk management. As an organization, the Employment Equity Act says you're not allowed to discriminate, which means that when you're bringing people into the organization, you want to be sure that that person is not going to end up, because today you're working next to Paul, tomorrow Paul he goes through through a bit of he goes through a change, and he then identifies as being gay, or identifies as being bisexual, or identifies as being cisgender, or he identifies to being this. And not everyone is comfortable with that. Not everyone is. But as a HR professional, it's about your job is to manage that risk that comes from that. How are you going to manage the people around you? And there's a lot of programs in which there's this process of reintegration, in which a person maybe goes through gender reassignment and they come back into the organization. There's a process of bringing everybody into a meeting. You let them know what's going on. You do some training. You do some sort of awareness campaign as to it. But Andrew, I think especially with Gen Z and millennials sort of being a lot more prevalent within organizations, I think there's a lot more sort of comfort with it than before.
Okay.
Tandawazi?
Judging from your answer to Andrew, I figure then it's illegal. I don't know. I'm just assuming it's
Yes.
illegal for HR personnel to ask you personal questions like, for example, are you married? Do you have kids? I know they're trying to gauge how much responsibility you have at home and how will you be able to take the responsibility of this job, because they usually say, well, married people often have problems and excuses and this child is sick and all of that. But I'm guessing that's also part of discriminating against someone, because
Yes.
if you're trying to exclude them from a position due to their personal life,
Yeah.
then yeah, it is illegal. I don't know if does the EEA
Yes.
specify, like specifically say like this for these forms of discrimination such as, and name them, or is it just left for interpretation?
No, absolutely. It is. You can if you don't get a job because, and you can prove because you are a woman, and you were discriminated against because you're a mother, and that's why, because maybe in the meeting they'll say, in the interview they'll say, this job requires you to work late and sometimes work over weekends, and we find that people with families can't really take on that level of responsibility. Are you a mother with a family? And you say yes, and then you don't get the job. That's absolutely grounds for discrimination. The only time where they can explicitly ask you for that information is once you complete the employment contract and you put down, they'll ask you who are your beneficiaries and put down the next of kin details. That's the only time you should be asked those type of questions. This is a minefield. It is a playing field, but it's absolutely, the thing is, there's so many interviewers, and that is why, as an HR professional, it is your job to make sure that when you brief people that are doing the interviews, because so often the first line manager would do the interviews because they're looking for somebody in their department. So you would draw up a short list, and you'll set up the interviews, and you will make sure that the person gets to the interview, and you check, okay, and then you don't have time to sit in on all the interviews. You might sit in on the second interview or the final interview, in which you will ask specific HR questions. But the first round of interviews, you won't be there. And it's your role as HR professional to make sure that manager is briefed, that you give them a list of acceptable questions, and you ask them explicitly to steer away from asking things like this. So that's your role. That's your job, to make sure that they don't mess up. Yeah, Bonte?
Yes, sir. I wanted to quickly ask, with the employee, or not the employee, yeah, Employee Equity Act, there's what is this? A concept of affirmative action that specifies exactly what you shouldn't discriminate against. So I had an instance last year where one of the students was saying that she didn't get into a university because she's white, and then she said it's because of these acts. But then I told her these acts only protect workplace environments, not schools.
Mm. You are correct. In terms of public universities, have been given by the department specific sort of, I won't call them quotas, because quotas has such an ugly word and such an ugly connotation to it. They've been given a very sort of clear guidelines in terms of admission guidelines, and say, listen, in terms of accessing higher education, um, these are what we require you to work towards. So they sort of, I don't even want to call them targets. They're guidelines. So the guidelines would say that, listen, and also universities know this. So universities know that in order to their business as well, in order to run, they need students that are funded by government, NSFAS students. And government is willing to fund these students. And they know that by taking on NSFAS students, they get access to students that are going to get fully funded. Their fees are paid, their accommodation is paid into certain programs. And then also for some programs like medicine, law, engineering, there are some universities use these guidelines and say, listen, we want more women into engineering. Therefore, we'll actively recruit more women students into engineering because the industry is looking for more women engineers. Does that discriminate against the men? No. It simply means that they're more actively recruiting women, and they will go to schools and they'll talk to girls about engineering and getting into STEM and the importance of STEM and so forth. And when it comes to, there's 2 places left, and they have 2 applications. One is a guy and one is a woman. They'll take the woman if they haven't sort of reached their guidelines. If they're saying we want to recruit 40% or 30% women into our engineering fields, into our STEM fields over the next 10 years, we'll actively do that as a policy. So when we get 2 applications and there's only 1 position left over, we'll take the one. So that is acceptable form of discrimination, and they'll be clear about it, and they'll say, listen, we're trying to get more girls into STEM fields, as an example. Yeah.
Okay, so just to clarify, there's no concept.
No, there's no laws. There's no laws. No, there's no laws that prevents people from being accepted into higher education, into public, especially publics. Privates are a completely different matter. It is the color of your money. It's not the color of your skin. Publics are very different. They've got guidelines, but it is those guidelines are just there. They're guidelines. They're not rules.
Okay, because when I was explaining it to her, when she was explaining her experience, she explained it like she was discriminated against, and I was trying to help her to understand that you won't.
Yeah, was the public university or was the private university?
She said it was public.
Okay. Yeah. Yeah, it's a bit unfortunate that there's that perception that just because you're of a certain race or a certain background, you get excluded, especially when we're talking about sort of triple BE and where it has come from and where it is going. It's that legislation or that is at a crossroads at the moment for us in South Africa, because let me just pause on there, because it's important. And I want to leave it for you, because as HR professionals, as future people working as future people within South Africa, that choosing this country as a place of hope, that sees this country as a place of hope, that you need to do your own research in this, and you need to sort of educate yourself in this, because we're at a place where the question I'm being asked, after 30 years, do we still need redistribution? So that's the one question, and it's a big question, because after how many generations will it take for Black people to feel that they've have equal access? 1 generation, 2 generations? That's a big question. And the next big question is, once empowered, always empowered. Therefore, if your parents received sort of benefit through this empowerment acts and through this empowerment policies, then should the children also still receive benefit again? So that's a big question. The next big question is, how did these policies, how did they truly do what they're supposed to do? which was to in somehow redistribute or distribute more equally some of the wealth that South Africa has into the hands of many through broad-based empowerment opportunities and policies. Has it resulted in what it set out to do? And the question to that is no, it has not. So in its current form, it's really empowered a handful to become super rich, and then many others not. But for someone that like me, that had an opportunity to go to UCT and had an opportunity to, in the mid-90s, have access to a student loan that was given through one of these policies, it has changed my life completely and the lives of my children. So for me, it was an opportunity, as it was for so many others. Then the question is, after so many years, do we still need them? Or should everybody be treated equally? Especially now that we've got one generation behind us, 30 years. So those are big questions, and I don't have the answers for them. You have to go do the research. If you, and again, I would encourage you as a HR professional that if this is the area that you're going to be operating in, if this is going to be your career, if this is going to be what you're going to be doing, you're going to be having these conversations with people all the time. Educate yourself. Ask yourself. Ask these big questions, because they are deeply philosophical questions that don't have answers. And the question is, what do we do next? What happens in the 2 years when we have another national election and ANC's majority falls even further, and we end up with another GNU that is sort of not functional? It is, everybody's pulling in their own direction. We don't have a clear direction for the country. And that is when people don't see when people don't feel there's hope, they become hopeless. And as leaders and as future leaders in organizations, especially in a very sensitive, highly contested, highly conflict role like HR management, you need to bring hope. You need to bring clarity. You need to, provide clarity where there's ambiguity. You need to provide a vision when there's volatility. And when there's uncertainty, you have to provide compliance. So to spend the time and read up. There's so many commentators writing on these type of stuff in the moment, because it's such a interesting time that we're finding ourselves in. And remember, this is your future. This is your South Africa.
Yeah.
Good. Yes.
I just wanted to add something on this topic. Because like you said, that apartheid did happen 30 years ago, but I still think that these laws are still necessary today, considering the demographic of poverty. There's majority of Black people who are women, colored, Asians who are still in poverty, but the other half is white people that are still thriving.
And that's the one view. After so many years, we still have a highly unequal society, and some would even say even more unequal.
Yeah,
I wouldn't go so far, because apartheid was as a person that lived through it was devastating, so I won't say that we worse off than we were under apartheid. But it is difficult to tell that to somebody that has no food on the table tonight and is living in a shack that is under mud, and they don't know what they're going to give their children tomorrow morning, because they have no work and they have no hope. And the only thing they can do is to drink, to make the pain go away and to be able to sleep. And it's difficult to tell that person that, if this was apartheid, you would have been worse off and they look at their current circumstances and go, I'm pretty bad off as it is, you know. So yes, remember, we're not the only ones that are struggling with these issues. There are many South Asian countries, Indonesia, Malaysia, not so much Malaysia, but Indonesia, India. There's many African countries, Kenya. They've had another flare up of violence again. There's many of these countries that are struggling with this very same issues around, and these are countries that didn't have apartheid. These are countries that are just struggling with high levels of inequality, where many have, and where few have and many don't have. So the one argument is that it's not just South Africa is not unique just because we had apartheid. It is there's many other countries that are going through the same transformation, well, not transformation, going through the same issues at this very moment. Yeah, but do go and read up, spend some time researching it. It is very much a issue of the moment. Good. Thank you very much, Bontle. Those very good questions. Sorry, I went on a bit. I really did go on a bit. But I think it was very, very interesting. It was very and I hope for you